Good morning. Let's go on the record. Today is December 6, 2024, and the current time is 10:10 a.m. I'd like to apologize to everyone for the delay in starting this hearing, but we are going now. We are in room 139 of the James C. Kirkpatrick Building, which is the Secretary of State's building on 600 West Main Street in Jefferson City, Missouri. The Commission has set aside this time today for a rule comment hearing in 3 files. The first file is OX-2025-0104, and that is in the matter of the Commission's proposed Rule 20 CSR, that's Code of State Regulations, 4240-10.155, and the proposed rescissions of 20 CSR 4240-20.015, 40.015, 40.016, and 80.015 of that chapter relating to the affiliate transactions for electrical corporations, gas corporations, heating companies, certain water corporations, and certain sewer corporations. The next file is OX 2025-0105 in the matter of the Commission's proposed Rule 20 CSR 4240-10.165 and the proposed rescissions of 20 CSR 4240-20.017, 40.017, and 80.017 relating to HVAC services, affiliate transactions. And the last file is OX-2025-0106. That's in the matter of the Commission's proposed Rule 20 CSR 4240-10.175 relating to customer information of electrical corporations, gas corporations, heating companies, certain water corporations, and certain sewer corporations. These rule rescissions and the proposed rules were published in the Missouri Register November 1st, 2024, and that's volume 49, number 21. Now, the commission is composed of the chair, Kayla Hahn, and commissioners Maida Coleman, Jason Holzman, Glenn Kolkmeyer, and John Mitchell, some of which are present via web today. My name's John Clark. I'm the regulatory law judge who will be conducting this hearing today. Now, due to a notice error, the hearings about the proposed rules and rescissions were published as being scheduled on 2 separate hearing dates. Today, December 6th, and also for December 10th. It is the intention of the Commission, it was the intention of the Commission to schedule all of those for the same date, which was December 10th, 2024. Accordingly, because the Commission didn't want to miss anyone, it is holding hearings on both of these days, December 6th and December 10th, for anyone who wanted to offer comments on the proposed rules or rescissions. If you are here today, and this is the only hearing date you can attend, I am more than happy to take your comments, and I'm not discouraging anyone from offering comments today. However, if you're able, I would encourage anyone who can hold your comments until December 10th, 2024 hearing, which will also be held here in this room at 10 a.m. on the 10th. You might consider holding your comments till then, and that will be for all 3 files on both days. I'm going to remind everyone, if you're speaking today so that the people online can hear you, be sure that you're using a microphone. If you have a cell phone, I'm going to ask you to silence it or put it on vibrate at this time. At this time, I'm going to ask attorneys for parties that are present to enter their appearance for the record, and then I'm going to ask who would like to offer comments. So I will start with the Commission staff.
Scott Stacy, Deputy Counsel, 200 Madison Street, Jefferson City, Missouri 65101.
Mark Johnson, the Chief Staff Counsel, with the same address. Thank you.
Mr. Stacy, Mr. Johnson, thank you very much. For the Office of the Public Counsel.
Good morning, Your Honor. Lindsay Van Gerpen on behalf of the OPC, and our address is 200 Madison Street as well.
Okay, thank you, Ms. Van Gerpen. On behalf of Ameren, Missouri.
Good morning, Your Honor. Jim Lowry on behalf of Ameren, Missouri, 9020 South Berry Road, Columbia, Missouri, 65201.
Thank you, Mr. Lowry. Are there any other utility companies present? I hear and see none. Is there anyone else present who is going to be offering comments today about any of the proposed rules or rescissions? Yes, and it's Ms. Gray, correct? Yes, sir. And who are you here representing?
I'm here representing Tower Grove Community Development Corporation at 2337 South Kings Highway in St. Louis, Missouri, 63110.
And since you don't have a microphone in front of you at the moment, I may ask you to repeat that when you get up to the stand. So we have one community development group speaking. Now, this is not a contested case, so there's going to be no cross-examination. I'm not placing anybody under oath today. You're not really witnessing, you're offering comments on these proposed rules and rescissions. If you provide comments, be sure to state your name, because there are 3 files here today that are being commented on. Please comment on the rule, proposed rule or rescission you are commenting on, and let me know your position as to whether you are speaking in support of the proposed rule or whether you are commenting against the proposed rule. Now, pursuant to Commission Rule 20 CSR 4240-2.108, parentheses 8D, comments will be taken from those supporting the rule, followed by those opposing the rule. Who's speaking in support of a rule today? Anyone?
Can I ask a clarifying question, Judge? I mean,
Of course you may.
we are in support of many aspects of the rule, but we also think there's one thing that needs to be changed. I don't know if that's in support or opposition necessarily. And I guess the second clarifying question, if we're going to be here Tuesday, and we can be here Tuesday, you would prefer us to hold our comments on the customer information rule, for example, until Tuesday and make all of those at the same time on Tuesday when the because our comments are due on the affiliate transaction rule today. We haven't even filed them yet. Is that what you prefer us to do?
That actually would be my preference. That
Okay,
would be my
that's fine.
preference. However, as I indicated before, I don't want to discourage anyone from offering comments today if they want to. But it would be my preference if you're going to be here on Tuesday, in relation to the other rules, it would be my preference that you hold comments until that day so that they can all be made at once.
We're
it just
happy
makes
to
for
wait.
a cleaner record.
Yeah, we're happy to wait.
Okay, so I'm gathering that there's some ambivalence as to whether some of the comments may be in support of, but there may be some things that people don't like about the rules. I don't think the rule that I just mentioned contemplates that, so in that case, I'm just going to call parties in the order that I took entries in and go ahead and let them make comments in that order if there's no objection. And I hear and see none. Okay, with that in mind, I will take comments from staff first, from the Office of the Public Counsel second, from Ameren, Missouri third, and finally from Tower Grove, if that's acceptable. Okay, on behalf of staff counsel. And you're welcome to use the podium if you like. You're also welcome to speak from your table.
Thank you. Thank you, Judge. Scott Stacy for Staff Counsel's Office, and here for staff. Staff is in support of these changes to every one of the rules that are before the commission as we speak.
Can you put your microphone a touch closer? I apologize.
Staff is in support of all the regulations that have been either rescinded or amended or proposed as before the commission here today, but we will reserve our position to provide comments until Tuesday. And we will also provide an additional breakdown of the comments of other parties and staff's position on those comments.
Okay. Thank you very much, Mr. Stacy, and thank you for holding your comments to Tuesday. On behalf of the Office of the Public Counsel.
Similar to staff, the OPC is planning to reserve its comments until Tuesday, though we have filed written comments for both the HVAC affiliate transaction rule and the customer information rule. But we will have further comments on Tuesday.
Okay, thank you very much, Ms. Van Gerben. On behalf of Ameren, Missouri.
Thank you, Judge. We are in favor of the rescission of the affiliate transaction rule that applies to electric, water, and gas customers. And we are in favor, generally speaking, of the customer information rule that the staff or that the commission has put out. As I mentioned on the record a moment ago, we have one issue that we'd like to see changed about it. But beyond that, I will reserve the rest of our comments until Tuesday on both the affiliate rule and on the customer information rule.
Okay, thank you, Mr. Lowry. Thank you, Ameren, Missouri. And on behalf of Tower Grove, would you like to come down and use the podium? And as I indicated earlier, you didn't have a microphone, so if you could please state and spell your name, give the organization you're here on behalf of, and then go ahead and offer the commission your comments on these rules.
Yes, sir, thank you. My name is Dana Gray, and I'm here representing Tower Grove Community Development Corporation in St. Louis, Missouri. We're at 2337 South Kings Highway. And I submitted a exhibit. If Brian could pull it up on the screen, I wanted to give some background that would help the commission understand my position with regards to data privacy. So first, Tower Grove Community Development Corporation, we're a 50C3 not-for-profit entity. We've existed for 42 years. And we focus on providing affordable housing to low to moderate income households. We work in South St. Louis neighborhoods, serving a population of approximately 36,000 residents and nearly 20,000 households. And this is an example of some of our rental housing that we have in South St. Louis. And we have been tracking the gas and electric data in our buildings, and it's been roughly 6 years since we started compiling that information. We roughly started in around 2018, and we've been benchmarking. That's the term that's used for tracking the energy use, benchmarking. So we've been benchmarking these buildings so that we could determine the efficacy of the improvements that we've made, and we're also benchmarking the energy in our office building. In the city of St. Louis and in Kansas City, there is a benchmarking ordinance that requires the tracking of energy for buildings that are 50,000 square foot or larger. So energy disclosure is another issue that's of concern, and I wanted to point out that energy disclosure, meaning making available the energy use and cost for a building, is available to home buyers. And here is an example of the Maris platform where realtors can list the utility average for a house that someone would consider purchasing. Yes, sir, do you have a question?
I do not have a question. I was trying to get my hand over the microphone.
Okay. So I wanted to point out that this information is available to home buyers. And if a realtor fails to list the information on the MLS, the potential home buyer can request and readily receive that information before they would make a purchase of a home. So in the city of St. Louis, and I'm aware that in the city of Kansas City, there's been discussions about an energy disclosure policy that would focus on renters. So renters would also have the capacity to gather the utility cost for an apartment or a home before they would sign a lease. And I have been providing energy disclosure for my apartments. I'm a landlord myself. I've been a landlord for approximately 18 years. And what I've been doing is calling Spire and Ameren and obtaining that information. And I ask for the 12-month average on those bills so that I can include that in my ad. And I have been including those in my ads for about 5 or 6 years. And here on this next slide is an example of the language that I include in my ad. So you'll see that I state that I, as the owner, I'm responsible for the sewer, water, trash, and recycling. The tenant is responsible for the gas, electric, phone, internet, and cable. For the past 12 months, the average gas bill was $75 and the average electric bill was $107. And then I give sort of a disclaimer and explain that occupant behavior and weather will greatly impact the gas and electric usage and cost. There's no guarantee that the utility costs will remain the same. In addition to occupant behavior, the weather will have an impact, as well as the utility rates could increase. So there's also on Ameren's website, they have a property manager page. It's called the Property Manager Portal. And once you register on that site, from that date forward, you are able to obtain the average utilities for the properties that you register. So this is an example of the data that I've been able to obtain for Tower Grove apartments from the date that I registered going forward. So this would save us time if we were going to share energy costs in our advertisements or verbally share that information with prospective tenants. The only downside is that you have to wait a full year before you have a full year's data to get an average of 12 months. But this is just a sampling of our apartments, and you'll see in the fourth column average cost, and that tells us what the average cost for the electric utilities are. This also has been really helpful for maintenance concerns, and we've been able to direct our maintenance staff person to go investigate heating and cooling systems when we noted that there was an extraordinarily high average bill for a particular apartment. And so then we were able to rectify a system that wasn't working properly, or it also directed my attention to the need to educate our residents on energy-saving behaviors. And so we had created slides that we sent to them, and then we also created a video. So this next slide is the natural gas information that I've obtained, and I obtained through Spire at their customer care email. And this is a sampling that I gathered in the spring. This is the precise data for apartments, and this is a single apartment, and this is what's needed and used for benchmarking when you're trying to track the actual precise information for specific unit. So this would be a single meter. And I'm wanting to share this information because the concept of energy data, energy disclosure, benchmarking, those terms all get thrown around, but I think that a lot of the people that are talking about it, and maybe the commission making the decisions about it, perhaps are never seen the actual data or know how to obtain it or what it looks like and why someone would want it. So this then is an example of the data that I obtained on a single apartment for 1 year from Ameren's site. They have a page that's BEEP, and I cannot remember, I think it's Building Energy Efficiency and Performance is what BEEP stands for. But this, again, is for a single apartment. It's the energy data. And for both cases, for Spire and Ameren, when we are requesting the specific precise data from the utility, I have obtained the tenant's permission to obtain the data, and my permission form says that I have access from move-in to move-out. So this is a reference showing the building typology in the state of Missouri, and it shows that Missouri has approximately 77,000 buildings that are 2 to 4 unit multifamily buildings. Approximately 21,000 units are buildings that are 5+ unit buildings. So there were comments that were filed that were recommending aggregation of data for 15 meters or 5 meters. And I found this information very helpful because it showed that the majority of buildings in the state of Missouri are actually 2 to 4 unit buildings. So if we were wanting to aggregate, then you would have to be pulling from outside of your own property to get that aggregated data if that was the rule as it went forward. So my suggestion.
Can you explain that to me? I'm sorry, I don't follow that.
Sure. And I don't understand exactly either. But aggregation, from my understanding, is combining multiple meters and so that an individual meter remains anonymous. And there were several comments filed suggesting 15 meters be combined for an aggregation of the energy data, or there was a suggestion of 5 meters be combined for the aggregation of data. For the purposes of benchmarking and a property owner wanting to track the efficacy of energy efficiency improvements and ensure that our heating cooling systems are working effectively, it's much more useful if I can see the individual meter. As homeowners, we get that information readily in our monthly bill, but when you own a building that's a rental property and the tenant is paying those bills, you don't get that information unless you can access that. And I also would believe that it would be much more difficult, potentially impossible for us to do this benchmarking if we had to pay for the data. Ameren, Spire, and Evergy, they've already been providing benchmarking information. They've already set up systems, assigned staff people to take care of this. So I would oppose the utilities to begin charging for that information. Also, the utilities providing a 12-month average cost for individual meters so that we can make renters aware of the approximate costs prior to lease signing would be super beneficial. It's been gratefully received by my prospective tenants, and it allows them to know whether they can truly afford a property before they sign a lease. So I would propose that by making that information available, we are avoiding eviction situations, we're avoiding late fees and the utilities having to disconnect people and then charging reconnection fees. So providing that 12-month average easily for renters and for property owners to share to renters is very important. So I think that's all of my suggestions. One other thing that I wanted to share was that affordability is defined by HUD as the housing on which the occupant is paying no more than 30% of the gross income for housing cost, including utilities. That's HUD's definition. But in reality, unless that information is available, the renter doesn't know what the utility costs are, the landlord doesn't know what the utility costs are, and even the agency that provides tenant screening doesn't know and is not able to determine whether or not the prospective renter can afford that house or that apartment. So making this information available would be a win-win, I believe, from the property owner, the tenants, and the utilities. And also, I want to again get back to the aggregation of data. I believe that the individual meter information is really important for those folks that are benchmarking, like myself and like our organization. But if there's a situation where the utility is selling the information or providing the information to outside organizations beyond those delivering the energy services, perhaps that's where aggregation of data would be appropriate. I just don't understand, and maybe I just need to have someone explain why it's important at this point for keeping energy data private. I understand and would agree that I wouldn't want the utility sharing my name, my address, my date of birth, my social security number, my credit card information. Of course, that information should remain private, and I wouldn't be asking for that information even to benchmark. But for benchmarking purposes, I would hope that single meter data could be available, and then if aggregated data needs to be pressed forward, perhaps that could be a separate rule for outside entities that are receiving that information. Does anyone have any questions?
Well, I'm going to back up just briefly for just a second, and you may have said this, and so I apologize if you did. You're commenting on proposed 20 CSR 4240-10.175, correct? Is that and that is OX 2025-01-06 in the matter of the Commission's proposed rule relating to customer information of electrical corporations, gas corporations, heating companies, certain water corporations, and certain sewer corporations. Is that correct?
Yes, sir, that is correct.
And you're not, and your comments are confined to that file, correct?
I don't know.
Okay.
I think so.
Okay. And I'm not confining you to that. I'm just trying to be sure that I'm getting the comments connected to the right
Okay.
rule.
I believe that that particular case is the case that is explicitly dealing with data privacy.
It is the only one to my knowledge.
Okay,
Now,
then that is correct.
and your concern with aggregation of meter data, just to clarify and kind of simplify, is that if a majority of the landlord-owned buildings are 2 to 4 units, that once you hit the 5-meter aggregation, you're drawing meter information outside your own building. Is that correct?
Correct.
Okay. If this rule were to be passed or approved by the commission as is, do you know what your expected costs would be?
I have no idea what our expecting costs would be because the rule that was written by the staff doesn't specify a cost. If you are you referencing utilities charging for the data?
Correct.
It doesn't specify what the charge would be, so I have no idea. But our organization had to get a grant just to get help benchmarking. So if there was almost any charge, I think it would be prohibitive.
Okay, so you believe that regardless, if this bill were to pass, or this rule, if it were to be approved as is, you believe there would be a cost to you and other landlords?
Yes,
But you don't at this time know what that cost would be?
correct.
Okay, thank you. Thank you for your comments.
Yes, sir.
I don't believe we have any, but I will go ahead and ask, is there anyone else here today who is going to be offering comments on these rules who is not holding those comments until until December 10th? Okay, I hear and see no one. If there are no further comments, are there any other issues or matters that need to be addressed by the commission at this time?
Judge, I wonder if I could just ask a quick clarifying question for Tuesday.
Please.
On Tuesday, if we're going to have comments for each individual case, will the commission call each of those cases individually or try to define which parts of the hearing pertain to which rule? Or would you like us to address all comments for all cases at one time?
I don't think that has been addressed yet. I do not know whether it's going to be me, another judge, or Chief Judge DePel on Tuesday. I'm assuming right now it may be Chief Judge DePel or perhaps myself. Does the public council have a position on what would be their preference? Because it doesn't appear that there's going to be a large number of groups commenting on these. I would like to do it in a manner that is most efficient for everybody.
It would be our preference to have each of the cases defined. I think our issues don't really overlap between each of the individual rules, so I think it would be a little cleaner for the record to have each case individually. But that would mean we would speak at least three times. Yes.
But if that makes the whole hearing clearer, that certainly makes a lot more sense. I will certainly take that back with me and run it by people. I like the idea. It would certainly simplify things if we took all comments on a file-by-file basis. So I don't have an answer for you now. I will have an answer for you before the hearing next week.
Judge, for what it's
Thank you.
worth, we agree with OPC on this. I think the record's going to be muddled if you don't take them file by file. You know, it would be difficult to have a clean record. So we agree with OPC.
Okay, thank you very much. Is there anything further that the commission needs to take up at this time? Okay. With that in mind, we will go off the record, and I will adjourn this hearing. Thank you for your participation today, and I'm sorry for the delay in starting the hearing.